All right, we're live. Good morning, Signature. I might look like Chris, but I'm not. So, I'm much funnier though. As much as he talks about his jokes, I'm funnier. All right, so we're going to get this meeting started off with some buyer and seller needs. Anybody got any new listings, new buyers, any needs?
I have a 2-bedroom, 2 full bath townhouse. Across streets at Deer Spring and North Fort Apache, 315.
Nice. 315 townhome. Anybody else? Tanya?
Oh, she's doing some business now.
Yes. Except Tom. So I have a 4-bedroom listing with a pool in Spring Valley that is going to be listed probably in a week or two. And it is fully remodeled, asking $525.
Nice. You heard it here first. Anyone else? Adam.
I've got 365 over on Rawhide by the airport, no HOA. Kind of RV parking, I guess, but outside the RV. 4 bedrooms, not fully remodeled, but it's been updated to new carpet and stuff. I've also got my Port Lavelle out at Southern Highlands, 2.5 million. Someone bring me a buyer for that. Anybody else want to know?
Beautiful. Anyone else? Going? Gone. Janet has an announcement.
Okay, first of all, this is the last time I'm going to bed. I need bowlers for Friday morning, April the 1st, 9 to noon at Sunset Station to benefit the Community Outreach Committee at LVR. To be registered and to bowl, I need your name and your money by Wednesday at 5 o'clock. Because Thursday morning I have to go to a meeting at the association and I'm turning all the money in then. We have 5 teams. Thanks to Annie Bushman, who has 2 of those. So out of all the rest of you 500, almost 600 agents, that means we have 15 people that are supporting the Community Outreach Committee. So.
And there's nothing funnier than watching me throw a ball down that bowling alley. I guarantee it.
There's nothing funnier than watching you do anything.
So, I need your money and your name by Wednesday at 5 o'clock. The other thing too, if you're under 40,
I don't make it, sorry.
if you're under 40, please turn in an application for who's who under 40, because it's not the fact that you were the top producer in the office, it's not the fact that you're just absolutely on every committee, it's a combination of things. And so if you need help with the application, help finding the application, Tyson Roberts is chair of the YPN committee, and I will also help you. So come see me and let's get those turned in. The deadline has been pushed back to April 4th, and there's a reason it was pushed back, which I won't say on air, but if you have a brain in your head, you can figure out why. So please turn your applications in. And one more thing, April 9th, Paseo Verde Park, the Green Valley office is hosting a client appreciation. It's going to be an Easter event for the kids at the park from 9 to 1. Is it 9 to 1 or 10 to 1? 10, oh, better. 10 to 1. This is for your clients to make one more contact with your clients. And FYI, Monica, who's sort of coordinating everything for the Green Valley office, she needs help. So we need vendors, we need people to just help coordinate things. So if you can help, please call Monica at the Green Valley office. And that's all I have. Thank you.
And Adam volunteered to be on the bowling team, so it just gets better and better. Make sure you track him down, get his money.
And Tom on one team?
Oh,
All right, so who needs CE class? Somebody's got to need them. All right, so this week, Wednesday from 10 to 1, we've got the Nevada Law Bowl being taught here. This Friday, we have property management 9 to 12 during the bowling tournament.
Choices, baby. Gotta make your choices.
All right, and then Wednesday, April 6th, we have Law of the Land. 10 to 1 here. Wednesday, April 20th, Agency Schmagency? What's the fuss? That's 10 to 1 also. And 10 to 1 on Wednesday, April 27th, contract, soup to nuts. Wow, that's nice. I don't know who names these. All right, anyway, there should be no reason why you guys should be waiting till the last minute to get your CE done. Remember, it's a lot more CE this year than it was last year or the year before, so keep that in mind. Also, if you're new, post-licensing starts Monday, April 11th and runs through Friday, April 15th here as well. Register at signatureschoolnv.com. Any questions? Fantastic. Let's turn some time over to Shelly Panzarella with Prosperity Lending for your mortgage moment.
Give it up for Brandon, so you can come back. Good job, Brandon. All right, happy Tuesday, everyone. Look to the person to your left or right and say, you look amazing. You look amazing. Okay.
He already knows.
So, there you go. I have to give you guys some great news today. In my hand, I have the updated information on interest rates. Where do you guys think they are? High. More specific. 4.25. More specific. 4.625. Okay, so for those of you who didn't hear, yesterday Jerome Powell spoke, and he is indicating that we are going to see rates, the federal rates, or short-term rates, increase. Last Wednesday he spoke, and they said about 0.25%. He actually just said yesterday that they will probably go up by 0.5 point, if not more. So, what does that mean for all of us?
Our CDs can go better.
Oh yes, put your money in the bank, because now you won't get 0.000175, you'll get 0.00175. So what that means to us is that mortgage rates have been affected by that as of today. So we are closely approaching 5%.
Oh,
I know, it's good, right? So I wanted to share with you guys what that looks like from a difference, because what's our average median sales price last month?
according to Brandon.
According to Brandon Roberts, your LBR president? 450. Wow, do you guys know that inside of your MLS you can actually pull up this information? So at a rate of at a sales price of 450, at a rate of 5%, what do you think the payment's going to be here? $2,415. Difference of what? Who can do the math on that? Because I'm a lender. What's the difference on that?
You have the calculator.
Minus 2280, $135. So let's have some perspective around that, right? Just because the rates are up half a point today, that's what that would look like, about $130 different for a person purchasing. This is a loan amount, actually. This is just a loan amount at $450,000. Does that feel different for you guys? Not as bad as saying the rates are 5%, right? For a person purchasing $400. Hopefully the person purchasing 450 plus can handle a difference in $130 in payment. Starbucks, absolutely, that's Starbucks. Okay, some other things I want to share with you is the rates for our down payment assistance programs. If you have buyers that are qualified to utilize the Home as Possible program and Home at Last, there have been some changes because of the interest rates. So for the first time home buyer program, which limits us to a specific income as well as sales price, that program will allow 2 and 4%. And then also for our median income conventional financing, that will also allow you the 2 to 5%, actually 2 to 4% today. My point in sharing this with you guys is that things are changing as far as our down payment assistance program. So for those general down payment assistance who are doing, because they were not first-time home buyers, we used to be able to go up to 4%. We're really only looking at about a 2% assistance for them today, if they are not first-time home buyers. Your teacher program and your Heroes program are still active, and you can see this. This is actually posted every single day. If you have any questions, you can always reach out to your Prosperity Lending loan officers. How many of you are actually certified for Home as Possible? Certified agents? You can go online and become certified for this. It's one way. You'll also get marketing assist. You'll also get some marketing collateral, but you'll be able to go onto a list. You can get this information daily, but you can always reach out to us as well. Any questions about this? Okay, one thing I also want to address, so with the changing of the market and our rates, we're hearing a lot of different lenders come out there and say, oh, I can offer our buyers this rate, 4.25, 4.5. I do want to let you guys know, Prosperity Lending, we actually compete and rate shop against ourselves. Usually when we hear from our agents, so I'd love to have you guys communicate with us if you're hearing that our rates may be off or for whatever reason. I can tell you that we're having a hard time competing with our online lenders such as Costco, right? Because I think I actually did lose a transaction with one of my agents who they went to Costco, but I can also tell you that the moment that the client decided to use Costco, that agent called me back and said, "The service is horrible, they will not talk to me, I'm fearful that this is not going to close, please do not cancel my buyer's transaction." But in good faith for our client, we allowed, they went on to the other lender. But because she did, we had that information, it gave us an indication that we had to rate shop ourselves again. Much like our business where you as realtors have your, $900 marketing, you have your 1%ers, you have all of these different types of realtors out there, we are selling ourselves again on our service to you. So if for some reason you're hearing that we may be outpriced, please let us know. Don't be afraid to talk to Myra, Gabby, Tony, Jason, Bev, myself, to let us know that we might be priced out of the market, because that would be a good indication for us that we need to do another sweep on our rates. We rate shop with the big banks. We rate shop with Cross Country, Guild. We rate shop with Cardinal, Celebrity Home Loans. We rate shop with most of our competitors who are in line with us, and even the big banks. I don't consider us a competitor with like your credit unions. Pretty tough. That's like you don't consider yourself a competitor with a 1%er, right? Because nobody sells 1%. Go ahead.
I just got actually this morning a quote from a client for Wells.
Yeah, we do Wells. Yeah, Wells Fargo is pretty easy for us to compete against. What we are finding for ourselves is that we're usually either in line or actually improved against their rates and fees. So I just want to share that with you guys, because much like yourselves being realtors in the market, it's hard, right? Because all of our clients are being bombarded with news and information, and giving this information to you, one, to talk about where the rates really are, you guys heard it, 5%, where our rates are, and encouraging you guys to communicate and be partners with us if you're hearing that your clients may be seeing a different rate, because that's an education aspect as well for your client too. I also had clients that said, hey, I'm at I got 3.99, they didn't realize when they got into contract there was actually 2 points charged to that 3.99. That's education, right? It's not all what you see on the screen. So, any questions at all about that? Rates. Home is possible. Okay, that's all I got. Thank you guys.
Thank you, Shelley. Who's nervous about rates going up? Stop it. Homes will still sell. There's plenty of inventory out there. There's plenty of buyers. Like I said, it might adjust the buying power of a buyer here and there, but don't get paralyzed by rates going up. In perspective, in 2019, what were rates? Right about where they are today, and the market was great. All right. When I got into the industry a long time ago, I remember when rates came down to 7.5. It was a great day, right? So it's all perspective. It's what you get used to, but you guys have to be out there and helping them understand the process and not spreading the fear about rates going up, because they are going to increase. Everything's going up. Dave just shared with me his coffee at Starbucks costs $2 extra a cup. So everything is going up. But part of the reason they raise rates is to fight inflation, okay? So it's a natural thing that's going to happen, but don't let it affect your business. We adapt, right? And if you're having any issues with that, get with one of us brokers and we'll help you through that process. All right, so I'm excited about today because we've got the one and only David Sanders here, our legal attorney. His voicemail says David Sanders, attorney. So he must be one. Anyway, he's here to share some stuff that he's seeing in the market and kind of give us a legal update. So let's give a big round of applause for Dave.
So I kind of want to share some personal things, but recently I unfortunately have had to deal with my parents passing away. And my father was quite the hoarder. And so as I was going through the files for their houses, I found their mortgage from 1987. And my father had circled their 14% interest rate and said, I'm so happy it's this low. So I think life is a lot about perspective. So I kind of wanted to share a couple things that I'm seeing and then some things that have happened to me personally to kind of give you some perspective as realtors. So the first thing that I want to address, which I know I've talked about over and over again, is the appraisal contingency. If you are a seller's agent, you really need to be careful about the language that a buyer puts in the seller appraisal language. I just got retained by another client to go down and fight over the fact that buyer's agent thinks that they're going to be able to pay X number of dollars over the appraisal, even though it is about $25,000 less than the list price. So if you are a seller's agent, I know we have language about this that we've talked about. This isn't going away. So make sure that you are addressing the fact that if you get a counteroffer that just says X number of dollars over appraisal, you want to counter that back if you're the seller's agent. You want to make sure it's very, very clear in the document that under no obligation, under no circumstance, is the seller obligated to sell the home for less than the purchase price. Okay? It's going to make your life easier. It's going to make Brandon's life easier. He's not going to have to call me and talk about why these people are threatening to sue us. Okay? So make sure if you're a seller's agent that you're really aware of that. It is unclear. There are several brokerages that are taking aggressive positions. The unfortunate answer is my opinion, Brandon's opinion, all of our opinions don't matter. The only opinion that really matters is a judge. But that's incredibly expensive to find out what a judge is going to tell us. So make sure that you've got that language in there on the appraisal. Okay? The next thing I kind of want to talk about is a personal experience. So my wife and I decided we were going to downgrade from our big house and move into a smaller place. And so I wanted to talk to you about how the experience of me being, showing my home, the process of going through the move, how much that impacted me, and how much I wanted to file ethics complaints on a weekly basis. So we have 2 dogs. We've got an older golden retriever and we've got a puppy, which means that if someone wants to come see our house, not only do I have to hire our maid to come through and make sure that their dog hair isn't everywhere, I have to schedule my day. I have to make sure that either myself or my wife is available to take our dogs out of the house so that you can show the property. I don't have enough digits on my hands and feet to tell you the number of agents who scheduled appointments and didn't show up. That's time away from my business, time away from my wife's business. And fortunately, I was calmed down to not file ethics complaints against every single one of these people because that's how angry I was. You say you're going to be here between 3 and 4? Okay, so I come home from my business day at 2:30, I bring the dogs out, I move everything, we get everything squared away. 5 o'clock, you don't even bother to show up, you don't even bother to call me. Okay? It does, and I thought realtors were better than Cox Cable. And so, be mindful of that. I understand your life gets busy, I understand your practice gets busy. A quick phone call to a listing agent saying, hey, we're not going to be able to make it, is a massive difference for me because I'm pushing my clients off. I'm pushing off calls from Brandon saying, no, I have to handle this. I think that instead of CE classes, increasing the number of classes you have, I think that they should make all of you move every 5 years. So you realize how much of a disruption this is for your client's life. When I think my house is incredibly immaculate and you're like, all those family photos, probably should take down. All these really nice things, you should probably take down because I don't want to take pictures of them in the MLS because, somebody could use them nefariously. You need to make sure that the house is in clean condition. How many of you have dogs or kids? Good luck keeping your house in a clean condition for showing. I think I spent more in cleaning services during that month than I'd had in the previous year because I realized that that's necessary to sell the house. But unless you've had to go through that, difficulty of, oh my gosh, who's going to take their day away? And we have dogs, so we had to clear the house out. So we got about an hour or two's notice, which really isn't a lot, but I understand that that's kind of the market. But I think that you have to have that experience as a realtor to understand what your clients are going through. And so when your seller gets really frustrated, you told me we were going to have 5 showings today. So I cleared my entire afternoon. I had the house professionally cleaned. I took the dogs to, doggy daycare. and nobody showed up. I know that's not your fault, I understand that, but I've gone to the effort of making sure that's clear. So the experience of being a real estate client, I think, is something that you need to be mindful of, so you can be empathetic with your clients about how much disruption in their life really, how much that really is. How much, I'm moving of a close of escrow day. I've hired movers. Anybody tried to hire movers in the last 2 months? It's virtually impossible. You give them your firstborn and a deposit of $15,000 and they might show up. So it's very difficult to do all these things. So I think that having that empathy for you as a realtor is important to those clients who are going through that process. And understanding how truly difficult that is. I think that's something that not necessarily something that's a violation of the code of ethics or your obligation, but being empathetic and understanding that moving as a buyer or seller is an incredibly disruptive process. And of course they're going to be emotional. I joke, I've sold 3 or 4 houses since I was the realtor, or the attorney for the realtors. And I joked with all of my agents that their job wasn't to tell me what the RPA said. Their job wasn't to tell me what the title report was. Their job was to talk me off of suing everyone when I got angry and just wanted to end everything. And so part of, I think, your job really is to be that empathetic voice, to listen to the clients who are going through an extremely difficult and stressful time. When a seller says, I need an extra 2 weeks, it's a lot on a buyer, particularly in our market where people are traveling, moving across the country. If I'm moving from, a different time zone to Las Vegas and you say, oh, the seller needs an extra 2 days to get out, that's a lot of emotional stress on me. Where am I gonna put my stuff? Where are we going to live? What are we gonna do with the animals? Those kinds of things. So I think that the idea of remembering that at the end of the day, you need to be empathetic with these people, I think is very important. Again, we talked about the appraisal issue, making sure that you put everything in writing. I can't tell you the number of cases that have gone to hundreds of thousands of dollars in mediation or hundreds of thousands of dollars in litigation where a mediator sits me down and says, look, if your client would have actually said, buyer, you should go get a mold test, and done it in writing, we wouldn't be here. We've got a situation where your agent's been doing this for 25 plus years. The only thing they didn't put in writing was, go get a mold test. So here we are. So the problem with the statute of limitations, the problem with the way litigation works is they're going to be asking you about things that occurred 2-3 years ago. I can't remember what I had for lunch last Thursday, let alone what my email and text messages were from 2.5 years ago. So I implore you, put everything in writing. It might sound like it's redundant, but if Brandon and I are sitting down and we're talking about how we're going to handle this case, the fact that we've got 17 emails from you saying this is what I've told you to do actually makes my life better. Versus you saying, well, I told them, and then the client saying something like, well, I relied upon the real estate agent, I relied on the professionalism, and there's nothing to rebut that, meaning that you're going to go in front of the jury and you're going to hope that they think you're more trustworthy than the client. And that's a dangerous gamble. So put everything in writing. I have a teenage daughter. I know you guys love to text. My daughter literally texts me from across the house, Dad, go to the kitchen and get me a drink, to which I call her and say no, because I don't want to get up. My point is that if you're texting, and I understand that's kind of the way it goes, make sure that anything really, really important, if a client is saying, I don't want a mold test, or I'm okay with, increasing the price to this, a quick email. This confirms our text of today's date, where you told me to do this. If this isn't accurate, let me know. That's enough. Because the email gives me email addresses, gives me dates, times, makes it a lot easier for me, if we have to go in front of a jury, to explain that you gave that information, okay? I'm not trying to tell you to be paranoid, but your favorite client can turn into your most unfavorite litigation partner very, very quickly. So make sure that you put that stuff in writing. Be mindful of timelines and due dates. I've seen a lot of issues like that come up lately with ethics complaints, with arbitration complaints, where there's time frame issues. If there are time frame issues, you really need to be on top of it. Making sure that you get the information that you need from someone that is actually reliable. I follow a couple of Facebook groups about real estate that I will not mention, and it is mind-boggling how many times people will say stuff like, I'm a licensee in the state of Maryland, and here's my situation. And then there are like 200 experts telling you what to do, but have no idea what Maryland law is, no idea what the issues are. I saw one this morning, they said, we disclosed that there was somebody who passed away in the house. Well, in the state of Nevada, what's the rule on that? We have a statutory language that says that it is not material relevant to real estate transaction, meaning you have no obligation to disclose it unless the condition of the property caused the death. Of course, there are lots of smart-aleck real estate agents who say stuff like, what if the house was haunted and the ghost caused them to die of fright? To which I said, I'm not even responding to this, go away. So there's that issue that you need to be mindful of. State law governs real estate. So an expert in Colorado may give you really great advice for the state of Colorado and really, really bad advice for the state of Nevada. That's why you're at a brokerage like Signature, because you have brokers that are available who know these things. Don't go to social media. Don't go to real estate agents who have sufficient time away from their business to respond to random comments about the business. Am I the only one who asks this? If you're so good at blankety blank in real estate, why do you have 2.5 hours to post on Facebook every day? Maybe I'm just a grumpy old man who just hasn't gone completely gray, but I don't understand why you would rely on it. Rely on your brokers. Call them. If they don't know the answer, they'll call me and we will figure out the answer for you. Okay? So that's the thing I would tell you to make sure that you're aware of. The other thing that I'm seeing a lot lately is, be mindful of your obligations under the Code of Ethics. I'm seeing a lot of ethics issues lately of really kind of things that I thought were pretty simple, things that I didn't think would be issues that are coming up. So just be mindful. If you ever have a question of whether or not what you're asked to do is a violation of the code, take the 5 minutes to call a broker. Take 5 minutes to get the answer before you say something. Okay? And just be mindful of that. I'd also like to take, I don't know how much time I have, so 30 more minutes, fantastic. All right. Does anybody have any questions before I launch into anything else? Okay.
I would like you to talk a little bit on solar.
Okay.
And some of those-
Yeah, let's talk about that great solar.
I'm a fan of the environment. I like the concept of solar energy. I'm not a fan of the way solar companies address their product and how it impacts the property. I don't think that I'm not an appraiser, I don't have any kind of expertise in that, but I don't know if there's any actual benefit. I will tell you from a legal point of view, if there is a solar system, it can be a gigantic mess in your transaction. So the first thing that you're going to want to do, if you're taking a listing that has solar, you want to verify the status of that system. Is it owned? Is it leased? Is there a UCC file? UCC stands for the Universal Commercial Code. Okay? It's a way that some of the solar companies secure their interest in the property. It's kind of like a lien, it's kind of not. It's messy. So those are all the information you're going to need from the client. You're going to want to make sure, if you're a seller's agent, that you are very, very clear on whose obligations it is to take over that solar process. You cannot just simply say in the MLS, there is a solar system, and assume that's going to be enough. You need to add specific language in the additional terms that says, buyer is aware that there is a solar system in the property. Buyer agrees to take on any and all interest and agrees to execute any and all documents to assume the solar process. Because if you don't do that, you could potentially get a buyer who says, well, I never legally agreed under the purchase agreement to accept this solar system. Yes, it's sitting on my house. Yes, I'm getting all of its benefits, but I'm not going to pay for it. And then you've got a seller whose credit is getting completely destroyed because no one is paying the solar system. And legally, they are still the only one who is responsible for the system. And they're going to look at you, because you're the quote-unquote real estate expert, who should have been aware of this. So if you have a solar system, if you are the seller, it is very, very important that you verify that immediately. Is it owned? Is it leased? What is the conditions? And that you are putting that in your first counter offer back to the buyer. That you're going to assume this. You're going to do everything that we need for you to do it. And you don't wait until the end. So you need to do your homework with solar systems up front because they are messy. And they have multiple ways to try to come after you. So don't wait until the end. Make sure that if you're the seller, that's up front. If you're the buyer's agent and there's a solar system, you're going to want to know this information as well. It's why the SRPD was updated to reflect this. They have to tell you, is it owned? Is it leased? You're entitled to that information. Make sure as a buyer's agent that you're getting that information during your due diligence period. Now, none of you are experts in solar energy contracts. Once you get all that information, you provide it to your client as a buyer's agent. It is imperative that you, in writing, say, if you have any questions about what you are taking on, you need to go speak to an attorney. I can't tell you what this contract says. Because heaven forbid you get it wrong, and then they end up suing. So your duty under NRS 645 is to say, here's the solar language, here's the contract, here's everything they sent over, here's everything from title, because there will be some information on the title report. If you don't understand this, if you're not sure what you're taking on, go speak to an attorney. Okay, that's very, very important. Sellers not so much because they've already entered into those contracts. The provisions for transfer are there, really can't change them. But if you're a buyer's agent, it's very important that you get that information to the client within the due diligence period. If the seller is not getting you that information within the due diligence period, you need to treat it like they have not responded to your request for repairs. It's that serious. You're going to cancel the deal unless you get us this. You need time to review it. And I would make the argument that if they haven't provided that documents during the due diligence period, it's a breach of the contract. Now, that being said, if you have a scenario where the seller has not provided the documents, you of course need to go speak to your brokers first. But that's how serious it is. Okay? It is akin to, I haven't responded to your request for repairs. We need to figure out. It's even more dangerous, arguably in some ways, than the request for repairs because the buyer is going to be assuming a contract. There are going to be terms in there that may or may not be friendly to them, that may or may not impact, for example, if they've got to run a credit score, it may impact their ability to purchase the property. So, you know, the environmental tree hugger in me loves solar power. The contract lawyer in me kind of hates it because it's a gigantic mess. And unfortunately, no appraiser has ever told me that this is going to make the property a whole lot more valuable. So I don't have an answer on to whether or not solar is good or bad, but I would certainly be looking and make sure. So if you're a seller and there's a solar, you have the obligation to disclose it, tell the client to disclose it in the SRPD, you have an obligation to disclose it in the MLS. If you are a buyer's agent and that information hasn't been provided, you need to jump up and down like a third grader who wants attention and get that information as quickly as possible.
And I think it's the clarity of what's written in that addendum so that all parties understand, and even taking it from a buyer's side, and this goes on even on the appraisal contingency, any addendum that you write, the clarity of what you write it, don't write an addendum to try to catch somebody off guard. Like, or that kind of the gotcha addendum. You know, like, hey, we request all this information, but nowhere in there does it say we're going to take it over. Does that make sense?
So my kid brother is a college professor, and he teaches sociology. And he and I were talking about writing, because he writes a lot of papers for academic institutions, magazines, journals, so he can get his tenure. And one day, a few weeks ago, we were both working in my folks' house, and I was writing a legal brief, and we were kind of talking about it, and he looked over my shoulder and said, Dave, you use the exact same phrase over and over and over again. Where is your creative license? Why are you like a novelist who uses additional phrases? And I said, I'm a lawyer. I'm not a novelist. I am not paid to be creative. I am paid to be very, very specific. So when I use the same phrase over and over and over again in the language, in the documents that I use, it's not because I'm not creative. It's because I don't want the other side to say, well, Sanders on line 17 used this phrase, and then on slide 25 used this phrase. So this has created an inherent inconsistency, so we can't listen to them. So when you are drafting language, this thing has always makes me very nervous. They're not attorneys. And I find it very interesting when I see realtors draft language. And for example, I'm currently working on a case involving about a $4 million property. $4 million property was not completed at the close of escrow. So the seller agreed that they would do about $250,000 worth of additional repairs. Now, anybody who's done commercial contracts involving construction, that's usually a completely separate contract. We're going to put together a completely separate document. We're going to have language in there that there might be a third-party company that handles all the money, that makes sure that once the work by the plumber is done and they've submitted all the invoices and it's passed all the inspections, this third-party company is going to cut a check. I know LVR did that with their building. It's pretty common with commercial construction. What happened in this case was a 2-sentence line in the additional comments on the RPA. So there was X amount of dollars will be held. This party will be responsible for doing the repairs. And that was it. So now 6 months later, the seller is saying, I have done all the work. I want my money. The buyer is saying, I still don't even have locks on my front door. The pool isn't done. This isn't done. That isn't done. And so the other lawyer and I are trying to figure out what exactly that 2 sentences means. And I'll be honest with you, sooner or later, that real estate agent is probably going to get sued. So if you get into a situation where you have to come up with creative terms for your additional terms, I would be very nervous about that. I would be wanting to talk to brands. It's part of the reason why we created standard language for most of the things so that you don't get into trouble. I'm sure the agent who wrote this, who represented both sides, meant well and didn't really think about all of this. Opposing counsel and I are actually arguing about whether or not the money that was withheld was supposed to be used for the repairs, or just that when the seller was done with the repairs, he got X amount of dollars. We're running into a situation where the former seller has not paid the contractors, so we're getting threats of liens. And it's a gigantic mess, and it's hundreds of thousands of dollars. I guarantee whatever the agent made off of this is probably going to go away in a future lawsuit because the home is not done. And when you are dealing with somebody who has the ability to pay $3.5 million in cash for a home, that means that they have the money to hire like a platoon of guys like me. They're not going away. So be very mindful of what you're putting in your additional terms. If it was up to me, the additional term section would be like, oh, line, maybe that much space. Because that's where you guys get in trouble, unless you've got language already written. That's the whole reason why we do it. So if you have a unique scenario like that, make sure that you're speaking to the broker up front. Make sure that you are communicating as to what that language is going to be, because errors in drafting under Nevada contract law are interpreted against the drafter. Meaning if you write it and you mess up, that's all I need. So now that I've terrified you completely out of your minds. Is there any other, before I jump on to the other things that I see that scare me half to death, this is why I don't get invited to parties. Let's talk about a couple other things. Your obligations under Article, I saw this one a couple of days ago. Article 10 of the Realtor Code of Ethics has been expanded to apply to any behavior, real estate related or not. Meaning that if you post anything on social media that could be considered a violation of Article 10, someone can file a complaint against you. And the fees for Article 10 violations, as Tom and Brandon and Janet will tell you, are extremely significant. And just over the weekend, I've noticed lots of memes about certain events that have occurred in sports that I will not mention, that real estate agents are saying, this is like our current market. And all I really want to do is say, you do realize that you've just posted to the internet an intentional violation of Article 10. So be very, very mindful of what you're posting. Because normally, if Tom makes a post and says, Dave Sanders is a jerk because he likes the Dodgers. Well, I like the Dodgers. It doesn't mean necessarily I'm a jerk. It's not a violation of the Code of Ethics because it has nothing to do with real estate transaction. That used to be the standard. Under Article 10 now, any comment that is made that impacts a protected class under the Fair Housing Act or under Nevada's equivalent is a de facto violation of the Code of Ethics. It doesn't have anything to do with real estate. You could just post up something that you say, this is not okay. But if it has to do with a protected class, it's a violation of Article 10. So you need to be very mindful of that. Yes, ma'am.
Does that include also commenting or liking other posts that have?
Yes.
What'd she say?
She said, if I like it, is that enough? And the answer is yes. Yeah, it
What
is.
if you were tagged, if you're just tagged?
Okay, so let's talk about this because this comes up in two areas. It comes up under Article 10 and it also comes up under antitrust law, which are, Tom's about to roll his eyes into the back of his head because these are my two favorite things to talk about, antitrust law and Article 10. The answer is, if you are tagged, that's enough. Now, the way I would handle that if I was tagged, I would say, I was tagged in this, please remove me from this thread, I don't agree with this, okay? And then if that person is an actual friend, I'd pick up the phone and say, you need to hold off. Because social media, we have a tendency to be very polarized there. With the way Article 10 works is it doesn't matter if it was your intent, if you did it, it's enough. And it came up because in Georgia, there was a realtor who was making incredibly racist comments on his social media page where he said, first name, last name, realtor. Really, really bad. But it had nothing to do with real estate. And so the local association couldn't do anything despite the multiple complaints from the public. So they went to NAR and said, hey, as realtors, we have an obligation to treat everyone fairly, regardless of protected class. And so we want the ability to sanction realtors who violate that. And that was changed about 2 years ago. And the fines are not cheap. They have a completely different fine system for Article 10 versus anything else. So the answer is no. If you're tagged, if you like, if it was me, and if you asked me individually, what should I do if I, on my social media, I said you should never talk about anything remotely related to Article 10, antitrust issues, or frankly anything political. Unless, if you're running for political office, there are ways to do that, but you really have to be careful. It's one thing to say, I believe in a balanced budget. It's one thing to say, I believe in small government. It's another thing to make comments that violate or accuse people of a protected class of certain behavior. And that's where it can get potentially at risk. Antitrust law is even scarier because antitrust law is what's known as a non-intent type of transaction, meaning the government doesn't have to prove that you intended to violate antitrust law. They just have to show that you did it. So if you're on a Facebook post that says, we should boycott X brokerage because they only offer $99 in the MLS, and you like that, and you say it is outrageous that any agent would act that way, let's boycott them. That's enough to trigger antitrust issues. So you need to be very careful about those kind of things. I would be very mindful of any kind of closed Facebook or social media group that I'm involved with that has conversations like that. There was a closed Facebook group in Florida of dentists. By the way, anyone whose profession is to spend their day in someone else's mouth is sketchy, in my opinion. But they decided that they would price fix dentures in Southern Florida. And the Facebook posts on their private page, it's like, not really private, any lawyer or any government agency can get a subpoena and get that. It's not like Facebook says, oh, I'm sorry, it's in our privacy vault, Mr. Federal Government, you can't get it. No. They can get that stuff. And they went to federal prison for that. So be very mindful of what the comments you're making about things on social media in those closed groups. Be very careful. Now, I'm not saying that your brokerage closed group, if you have one, is there something that you should be involved with because that's monitored. If somebody starts spouting off things that are going to be a violation of Article 10 or antitrust, your brokers and moderators will address that. I'm talking about, you get an invite from, Western States Realtor Group, and all they want to do is complain about certain competitors in your market. I would not be posting that on social media. Okay? If it was up to me, and Tom and Brandon and Janet can attest to this, if it was up to me, I would tell you no one needs social media. But I realize that's not the way it actually works. I mean, you unfortunately have to have a social media page. Since we're talking about social media, let's talk about one other thing. As a real estate agent in the state of Nevada, I do not think that there is a difference between your personal page and your business page. I think that is a fallacy. The real estate division's position is, if anybody contacts you about real estate, it is a advertisement, and it is subject to NRS 645, NAC 645, and I think the realtors would argue that it's subject to the code. It used to be that you could have a personal page where you could kind of, talk about your kids and how much you love cat videos and things like that, and have a business page. But as soon as that old friend from high school texts you and says, hey, Tom, I'm going to move to Vegas. Give me a call. I want you to be my real estate agent. Guess what your personal page is? A business page, which means it's got to have all of the NRS requirements for disclosure of your license number and all that kind of fun stuff. So in my opinion, I don't think that you have the difference. And I would err on the side of caution because I know that the division has hired somebody whose entire job is to watch you on Facebook. Okay, so what did we learn today? Dave tells us to never write anything, never use our phones, never go on social media. He's like the angry grandpa that we wonder why Brandon invited him to the office to scare us. I'm not saying that you can't use those pages and be very aggressive. My TikTok feed admittedly is mostly cat videos, but occasionally you realtors kind of jump in there, and some realtors really use TikTok well. Some of you really use Instagram well. Some of you use LinkedIn well. It's not necessarily that you can't use them. It's that you have to be mindful of, does it have my license number? Am I saying things that are going to get me in trouble? I love the fact that, realtors are out there using TikTok saying, here's a new property that I've got listed. As long as they're in compliance with the statute and doing everything they need to do, go for it. Use that new technology. My attention span has resolved down to about 87 seconds. So if you're going to introduce yourself as, hi, my name is Jim, and I'm a real estate agent signature, I've already moved on. So I'm not saying that that's not a bad thing. What I'm saying is that you need to make sure, if you're doing your media yourself, you need to make sure you're in compliance with the statute. And I know there are CE classes. I know Brandon's talked about this. I know Tom and Janet have talked about this. So it's not like that information is not out there. If you are using a company, then you need to make sure it's very clear what it needs to be. License number, full name, that kind of thing. And then you just need to be really careful about the types of things, that you are tagged in. And the reality is everyone is entitled to say what they want to say about different political issues. You as a realtor, under Article 10, you have a higher standard. You agreed to that. If you don't want to be bound by that higher standard, Brandon, please forgive me, your only solution is to not be a realtor anymore. Okay? So you need to be mindful of that. So if you're working with a company, setting forth those standards, and if it's a company that works with realtors, this isn't anything new. It's nationwide. It's been going on for a couple of years. This isn't anything that they should be surprised about. Okay? Yes, sir.
Be very wary of varied messages and videos.
I'm sorry?
When it comes to that Article 10, be very wary of varied messages and videos, because there's a tactic that's being used right now where they'll start the video off with the little cats playing, and you hit like, and you just sent it to your sphere. But 30 seconds into that video clip, it turned into some other very nefarious thing.
Yeah, so that's a great comment. If you're going to be sharing posts or anything with your sphere on social media, I would tell you to watch it through all the way to the end, because there are scenarios where the video starts off innocuous and then turns into something not okay. I like to joke that don't post anything on the social media that you wouldn't want your mother, your priest, or a jury of your peers to look at. And that's the view you need to be looking at. Is this going to offend those three people? Most importantly, jury of your peers. You've heard me tell this story before, but there was a Boy Scout troop in Utah that was a place called Goblin Valley, which is a federal preserve, and they have these great sandstone monuments. Well, a group of them claimed that one of these statues was unsafe, so they pushed it over. Turns out that the two Boy Scout leaders were actually convicted of felony destruction of federal property. They were banned from the Boy Scouts. My favorite part about this was the guy who pushed the rock over was suing his employer because he said that his back was so damaged that he couldn't do physical labor. So guess what the defense lawyers did? They found the video of this dude pushing over like 300 pounds of rock and said, "What are you doing?" So not only did he is a felon, got kicked out of the Boy Scouts, but he lost his personal injury claim. So anything you post on social media is fine. So just be mindful of that. I'm not saying that you shouldn't use it. I think that social media is an incredible tool. I think you have to use it as a realtor. I just think you have to be smart about it, and and separate what your personal feelings are about issues of the day versus your job as a real estate professional.
We're seeing a lot more of, we're getting close to closing and the seller wanting to cancel. I mean, is there a way or a right the seller has to cancel, and how should an agent handle it?
Okay. I'm going to break that down into two things. If you're the buyer's agent and the seller's agent. The short answer is anybody can break a contract. The question is what it's going to cost you. So can a seller cancel a contract the day before close of escrow? Absolutely. Are there going to be damage to that? Absolutely. Do you need to be the agent that says, "Look, Mr. Seller, I understand. If all of the, and it's all going to be fact-based. I love you realtors. I know what you really want me to say is, if you do this, you'll be okay. If you do this, you'll get in trouble." But this stuff is all going to be fact-based. Are there any contingencies left? What are the issues that are out there? Are there any issues? If the seller just gets cold feet 2 days before the close of escrow, they can cancel the contract. They can do that. Depending on the price point, it might result in a specific performance lawsuit and tens of thousands of dollars of attorney's fees and damage. They need to be aware, look, if you're going to cancel this contract, you can do it. We can't force you to sell the house, but you may want to go talk to an attorney and find out what your issues are. This is a particular issue, the higher price point you get. So I'd be mindful of that. If the buyer, is there a contingency? If the seller can cancel because the buyer hasn't complied with the financing contingency or something along those lines, they might be able to do that. It's going to be highly fact-based. So what I would tell you is if you have a buyer who wants to cancel, make sure that you're putting in writing, what the contingency status is. And then always in that email with, if you have questions about what your legal rights are, you need to speak to an attorney. And then you immediately need to go run to your broker and talk to them about it, because there are all kinds of issues. Because what will happen, despite them being your bestie and you guys go get Dunkin' Donuts in the morning before you go look at the house, they're going to turn around and sue you. Well, I relied on Brandon to tell me what my rights were. And then the seller ended up suing me for specific performance and $50,000 in attorney's fees. So it's going to be very, very fact-based. And then, be very mindful. If you're the buyer's agent and the buyer wants to cancel, making sure that you're clear with what their contingencies are. For example, I have a scenario that I'm currently defending where buyer wanted to cancel the property, didn't want to buy it, was unhappy with the square footage price. That's what they said. So they tried to use the loan contingency to get out of the contract. Unfortunately for the buyer's loan officer told the seller's agent that the buyers had sufficient funds to buy the property in cash, didn't even need a loan. Which makes it a whole lot more difficult for me to try to make the argument that they terminated because of the loan contingency. I don't know who the loan officer was in that situation. My response back to this whole situation was, there's somebody who's responsible for this, and it's your loan officer for disclosing information to the other side of the equation. I had a personal situation. I'm looking to buy an investment property, and the CC&Rs came through. This condo unit here in Las Vegas. And I lost my mind when I saw the resale package. And then it made me wonder how many agents actually caught this stuff. For example, I said, it's really nice that you sent us a litigation statement letter. It's not okay that it's dated December 2018. This was this month. So thank you for sending me a litigation letter from 3.5 years ago. Thank you for sending me your budget from 2019. I'd like to know what your reserves are today. Thank you for sending me your reserve analysis from 2016. I'm at the position right now that you have not complied with NRS 116 because this stuff is 3.5 years old and none of this is valid.
But it's what the HOA sent me, Dave.
Exactly, which made me wonder how many other people got this packet, forwarded to their clients, and I'm a grumpy lawyer. I read that stuff.
It's on condo search.
And so, it was really simple stuff. This stuff is dated 3.5 years ago. I get it's been COVID. I get that. But a litigation letter from 2018 is not okay. Because litigation letters, I would argue, a lot more than 30 days old are not there because we all know lawsuits can happen at any moment. And I felt bad for the seller's agent. I don't think that they knew. I know they just probably just said, here it is, here we go. And then I wondered how, because this is a pretty large condo complex here in Las Vegas, I wondered how many other agents didn't even bother to look at this stuff. Now, I'm not saying that you need to go through and look at this. What I am saying is, that being mindful of the documents that are produced. Now, fortunately, I wrote back to my agent and said, this is not okay. And they forwarded it over to the listing agent, who then forwarded it to the HOA, and they fixed it. They magically had all these other letters, which I was okay with. We had time to review them within our time frame. But my point is, if a client is looking for a reason to terminate an agreement, it's going to be very fact-based. You've got to look at it, and you got to make sure that you're not, that they're not being undercut by other people's behavior and being mindful. Do I think that you have an obligation to go through a review and make sure those dates are there? Absolutely not. That's the job of the seller, of the buyer, to verify that, and frankly, the homeowners association. It didn't make me nervous as an attorney that this stuff was old. It made me nervous as a potential buyer of how is this HOA run? If I'm going to buy a place in this, am I just walking into a massive, massive mistake with the HOA company. That's what I was mostly concerned about. I realized people make mistakes. I realized they may have just sent us an old packet, but holy cow, this made me nervous. So, now that I've told you to not question everything and then not question anything, it's clear as mud, right? Feeling really comfortable about your decision to become a real estate professional? What I will say in closing before I turn this over to Brandon, the reason why you're at a brokerage where you are is you have brokers who can help you through this. I get the crazy questions of, what happens here, what happens here. If you are a successful real estate agent who does a lot of transactions, who does everything, who dots your I's and crosses your T's, I'm probably never going to know who you are. I only know the ones who make mistakes and cause problems. And so what we're here to do today is to give you the tools that you need to make sure that you and I don't have to get to on a first name basis unless it's absolutely necessary.
Thank you, Dave. Who's scared now? You all should be, because you can get sued for doing absolutely everything right. So that's why it's important to document everything, because you don't have to do anything wrong for someone to file a lawsuit. So anyway, appreciate it. If you're doing anything that you need special verbiage, whatever, please reach out to one of the brokers. We'll reach out to Dave, AB. We'll make sure that we get it right. Because the thing I'm seeing the most right now is ambiguous language in addendums that can be taken either way. You meant it one way, they read it a different way, and it happens. It's kind of looking at those photos where you look at a photo and you see that it's this color or that color, and the other people see it opposite of that. It's the same thing. So, all right. So make it a great week, and we'll see you around if we don't see you for the next sales meeting.